Difficult parties cause creative thinking. In my office, we have a number of simultaneous litigation matters going on. I have a Surrogates Court contested matter, chiefly being handled by my associate, and opposing counsel on the other side is really putting up obstacles, significant obstacles, to resolving the matter. This individual has put forth a set of demands, and in the negotiated back and forth between law firms, we have conceded a number of points. And to the credit of the other side, they have also conceded a number of points. However, we have a few issues, let's say 4 issues, that cannot be resolved. And we believe that a few of those issues are issues that really are not appropriate to ask for. They're not what could be achieved at the conclusion of a trial. It just is so outside of the norm. Internally, we think this other person just doesn't want to settle, possibly to raise legal fees for the benefit of that firm. I don't know. That's putting a bad motive to this, but it just doesn't seem to make sense. It's like asking a person if, we won't settle unless you can levitate, right? You just can't levitate. I need a jetpack. I need a few balloons like Up, but I can't levitate on my own. And that, in sum and substance, is what the other person is asking for. Now, let's contrast that with a divorce matter that I'm also involved in. And similar issues. One side does not want to settle and is asking for a significantly high settlement amount. And then the other side is more reasonable. But we have to think creatively. It might be in the best interest of the person that doesn't want to settle to actually settle for an amount higher than what might be, at first blush, reasonable pursuant to the law. So what I mean by that is you may have to overpay an actual amount just so that you can underpay the total costs of litigation, right? Because in a divorce, there are expert witnesses, there are appraisal reports, there are attorneys for children, and legal fees for both sides. Let's say you are required by law to pay $100. That would be the settlement amount, right? Just some absurd number. Maybe it's in your best interest to pay $120 so that you don't really try to win to pay $100 plus the cost of your lawyer and the other side, if you're the moneyed spouse, and the attorneys for the children and other litigation costs, maybe the upkeep of property, maintenance, pending a decision of the court. So you might want to pay, in my example, $120 rather than winning a victory of only paying $100, but then having every other expense add up to $50, right, in this absurd example. So you're paying $120, overpaying, so that you can underpay the total cost of litigation. Sometimes that's what needs to be done.